right, I do see Mr. Goff is now with us. Ms. Kraus, could you update me as to this case, please?
Yes, this hearing was adjourned from April 24th. That was previously adjourned from an arraignment hearing on March 27th when the bond was reduced from $5,300 to $300. But the defendant appeared from the Otsego County Jail on April 24th as the bond was not posted at that time. This hearing today is to address the forfeiture of that bond as that was paid and he no longer appeared on the inmate list as of April 25th. After that, additionally, upon his release, he was to do a few things to report any income that he received and to provide job searches. There's been no verification of income or payments, but he has provided 5 weekly job searches on May 4th, 11th, and the 19th. And then the third condition was prior to today's hearing, the defendant is expected to make payments and to show reasonable efforts to gain employment if they're not able to pay their obligation in full. His support obligation is $324 with an arrears balance of $21,725.27.
Thank you very much. Mr. Goff, as to the forfeiture of the bond and application towards your payments, do you agree to that?
Excuse me, can you say that again, Your Honor?
Yes, the child support staff is asking that the bond that you posted, the $300, that be forfeited and applied towards your back child support payments. Do you agree to that?
Yes, Your Honor, yes.
All right, so we will apply that $300 towards your back payments. Tell me what you've been doing to find work.
So I have a couple apps on my phone for job search, and I've just been looking on there and applying on there. I just got some new apps on there that I'm hoping I might get a job at.
So what are these apps for, and how many places do they search at?
So the one's Indeed and the other one's Snag a Job. They're you can apply to jobs on them and find a job. And quite a few. As far as like as many jobs are on them, there's a lot actually. There's a lot of jobs on them.
How many jobs here in northern Michigan?
There's usually quite a few. Now, it doesn't seem like there's as many on there this time as there usually is, but there's still quite a few.
So how many of you applied at?
I want to say 15 now or something.
In 3 weeks?
Yeah.
So how long does it take you to apply for a job?
So I've called on a few and haven't gotten them, but usually it doesn't take me long. Usually a couple weeks and I find one. So I've used them before. I've used them probably five times before or more, maybe even more than that, and it usually takes me a couple weeks or so to find one.
Let me make my question a little more specific. How much time in a single day does it take you to make an application?
It only takes maybe an hour or maybe hour and a half to apply to 5 jobs.
So 3, 4, 5 jobs. So what are you doing with the rest of your time?
Not too much. So I went and stayed over at my sister's for a little under a week and just spent time with her. But other than that, I've just been here around the house. So I was working with my dad a little bit before I got put back in jail the last time. He's still working, but I haven't worked with him since I've been home. I was hoping just to continue working with him a little bit when I got back home, but haven't worked with him since I've been back home.
How long have you been out of jail, Mr. Goff?
I want to say close to a month now, close to a month.
And in that month's period of time, you have applied to 15 jobs and gotten 0 jobs and made 0 payments. Do you think that that is enough to keep you out of jail again?
I definitely don't think it'll satisfy or fulfill.
Then why are you doing that? Why aren't you out there busting your butt to get a job?
Well, I could try a little harder, I guess.
Well, that would be the understatement of the year. What is it that you need? Do I have to have somebody hold your hand and take you to a job site and ask for work?
No, Your Honor, not at all.
Then what do you need to do?
Like I said, it usually only takes me a couple weeks, if that, to find a job on there. But I guess I just really need to buckle down and put in the effort, I guess.
Mr. Goff, I find that your lackadaisical attitude shows me that you do not have the ability. No, I'm not going to say that. You do not have the desire to make your payments. You've not made a good faith effort to find work. And you have the ability to get a job because you've gotten jobs in the past. You've worked with your dad in the past. You've had other construction type jobs in the past. There are, and I know that I've told you this, there are probably 50 jobs on the whiteboard at the front of the friend of the court's office that are open right now in Gaylord. And the only thing that you've done is play on your phone a little bit. So I find that you've not made a good faith effort to get a job, that you have the ability to get a job, and that you came out of jail because you didn't get a job. And now I'm going to put you right back in jail. You will report to the jail for 7 days, beginning today, May 22nd at 6 p.m. And then when you get out of jail, we're going to have another hearing next month. So you got 3 weeks when you get out of jail to get a job. And if you don't get a job, you're going to go back into jail again for 7 days. I don't know what to do to light a fire under you, but this is what I'm going to try next.
So the bond is just doesn't count for anything?
The bond got you out of jail last time. You're the one who wanted to stay there last time. So you got out for 3 weeks and you did nothing for 3 weeks after being in jail. And the best you can tell me is, I guess I should do a little bit more. No, there's no more guessing. You've been playing this game long enough. Okay, you're $21,000 behind. Grow up, get a job. And because you haven't in the last 3 weeks, you're going to jail for 7 days, starting today at 6 p.m. You're free to go until 6 p.m., Mr. Goff, and then you're at the jail. That's all for today. Alicia Ballinger and Gerald Ballinger, file 12-14526-DM. Ms. Krause, can you update me as to this matter, please?
Yes, this hearing was adjourned to monitor the defendant's Social Security disability case. Since the last hearing, We have been provided a letter from Social Security indicating that there is a fully favorable form, but there has not been any payment or anything like that. That form does indicate, though, it can take additional time, as there is probably an application for means tested income as well. Support has been abated already with an arrears balance of $4,116.65. Given that information, I would just request to adjourn out probably till August 28th, as depending on that determination, friend of the court would have the time to potentially initiate a new support recommendation calculation if needed, or potentially address anything else at that time.
Mr. Ballinger, do you have any objection to that?
No, sir.
Ms. Kraus, is there any other documentation that you need from Mr. Ballinger?
Just if he receives any additional information regarding anything through Social Security to help us expedite that process to hopefully have everything addressed before the 28th hearing of August.
All right, Mr.
Would you like
Ballinger,
me
I'm
to
going to
bring-
order that you, go ahead, sir.
Would she like me to bring the papers that I got from Social Security to her office?
Mr. Ballinger, has there been anything more recent than when your attorney, Mr. Legal, dropped off information? Have you received any paperwork indicating what you will be receiving monthly?
Yes, I have that.
Yes, if you could provide that, that would be great.
Okay, I'll be down to your office shortly.
Thank you, Mr. Ballinger. We'll do what the friend of the court has requested. We'll adjourn till August. I'll ask Mr. Ballinger to cooperate with the friend of the court in providing paperwork, and I'll ask the friend of the court to do a new review based on his new disability income information. Thank you. Next matter is Alexandria and Ronald Holt, file 16-16212-DM, set for a show cause.
I have neither party, Your Honor.
Neither party has appeared at the call of the court. Ms. Kraus, have you had contact from Mr. Holt?
I have not had contact with Mr. Holt. We would be requesting forfeiture of the $1,200 bond that was posted with Otsego County on May 4th to be released to our office. Outside of that, most recently from that bench warrant, I guess we would just be seeking an additional bench warrant, as his current support is $273 with an arrears balance of $4,719.39. There hasn't been any contact or additional information received from him.
All right, I will grant your request to forfeit the $1,200 bond that he previously posted. And for his failure to appear today, we'll issue another bench warrant with the standard 25% bond based on his arrearage, whatever that works out to be.
That amount would be $1,200 plus $100 in court costs.
Thank you. Let's do that. Next matter is Christy Wheeler and Cody Frost, file 16-16273-DP, set for a show cause. I do see Mr. Frost is present. Ms. Kraus, can you update me on this matter, please?
Yes, this hearing was adjourned from February 27th to monitor the defendant's continued payments. As the defendant was to continue to make $302 payments each month or appear today. Someone did come in and make a payment on his behalf on May 19th in the amount of $600, but I wasn't aware of that until looking at the system this morning. The arrears balance is $16,326.78. I mean, friend of the court would prefer to consistently receive payments versus him having the prior commitment to serve 7 days in jail. Just asking that the court reiterate to him the importance of making the payment and having contact with friend of the court.
What is his payment history prior to the May 19th payment of $600?
It was, let me look, I apologize. In February, there was a payment of $302, so nothing was received in March or April. And that's the reason the February's hearing was adjourned in advance, because he had made that payment prior.
So basically a $600 payment in May made up for March and April, give or take a few bucks. He
Yes,
hasn't made his May payment yet.
correct.
Mr. Frost,
Based on
go
how the
ahead.
system works, it all went towards May's obligation and $247.47 towards arrears. So
All right.
yes, that would be the case.
Mr. Frost, what seems to be the problem with making your payments monthly on time?
The last time I spoke with you, you got on me pretty hard, told me to get a real job. I got emotional, but long story short, I started my own business. I am fully licensed and insured, and my last couple of checks I've been investing in tools, but I had the $600 check was a check that my customer had held. On my second job that I did, I had a mistake, and so it stretched it out like 3 weeks. It pushed everything back, but I'm learning, and it's going to get better. Your payments are going to become more consistent. I didn't have no choice. I was robbing Peter to pay Paul, and I just wanted to make sure I had a good chunk in front of you before I'd seen you today.
Well, that's smart, because that is going to buy you some time. What kind of business are you engaged in?
Roofing, metal roofs.
That is a business that's going to have some ups and downs in it, literally. And it's going to be tough to do consistent in the wintertime. So what is your plan for those times when roofing is not available to you?
Snow removal, and maintenance. I'm subcontracting for Midwest Exteriors, and there will be like upkeep and maintenance and snow removal, and it's probably going to get really hard. I'm not going to, beat around the bush, but I'm going to do my best. I have my license, so I can put a plow on my truck and just do my best.
All right. Well, here's the deal. All I can ask you to do is be wise in making decisions and then work as hard as you possibly can. So it seems to me that you've taken my statements to heart and you've tried to provide a path forward. So I'm going to give you some rope here to see how it plays out. Not every business that starts up is going to make it. And so I understand that. But all I can ask you to do is, if you see the business failing, you got to do one of two things. You either got to work harder, or you got to make a decision at some point that this business isn't going to work, and I've got to go do something else, or I've got to get a second job. Your arrears are high enough where I can't just say, well, I'll give you some time and we'll think about it and give you some grace. You've used up that. So I applaud you on getting some money into the friend of the court. That was a good idea. You need to continue to do that. I would prefer, and I think the friend of the court would as well, that come in on a regular basis. I understand job work. It's not always paycheck, on X date. It's when the work gets done. So I understand that. But that doesn't give you the right to just blow us off either. And I'm not saying that you did that, but for future reference, You've got to be regular. So make some kind of payment, even if it's $20, right? $20, whatever it is, make a payment every month. And then when you get enough money to make a full payment, make up for what you missed the previous month. But you can't just do nothing for 2 months and then just before you come to court, put a big chunk down and hope that that's going to continue to work. It worked today because we haven't had this conversation yet. But now that you know, you got to pay something so that we know that you're not just blowing us off. And as long as you're doing your best and you're working hard and we can see that you've got a pattern of, all right, a little bit this month and a lot next month. All right, he's got jobs that are flowing, but it's up and down and we can work with that. But when you do nothing, we have to assume the worst, which is you just don't want to pay. Does that make sense to you?
Absolutely.
All right. So I'm hoping that your roofing business takes off, because now is the time where you really need to make some hay. You really need to push it now. So go do that. We'll give you some time. Make your payments every month now when you're making good time, so that you can build up some goodwill for the future when you may need a little bit of grace and say, well, I didn't make as much this month. I gave you some, but I can't make all of it. And I'll say, all right, during the summer, you did a great job. So I'll give you a little grace in the winter, because I know that you're going to make up for it again in the summertime. So go make some hay, make your good payments now, build up some goodwill. Ms. Kraus, do we need to see him again next month, or do we need to bounce it out 2 months?
I would say based on the payment that he did make out 2 months, I would just like to mention to the court that his amount that he's paying, the $301 that was previously ordered, just covers current support, as there's no orders on arrears in regards to anything. So we would just request him to make the effort to pay his support and something towards arrears in the next 2 months.
Do we need to have an ordered on arrears? Do we need to have an ordered on arrears recommendation?
Maybe we could address it possibly out at 2 months. I can send out that recommendation, but I definitely don't want to set him up to not be able to meet the obligation right now, get him set on track in regards to at least meeting his obligation.
All right, well, let's do this. I want to give him an opportunity to succeed. So let's bounce it 2 months. And then at the next hearing in whenever that is, June, July, somewhere early August, whenever it gets set, bring this up again on the order on arrears amount, and we'll make an assessment then of whether or not he's been able to make payments on his own. If he's making payments on his own, I may not need to have an ordered on arrears amount. If he's not making payments towards the arrears in addition to the current amount, then I want you to remind me that we need to have an ordered on arrears assessment done and a recommendation done, and we'll do it at the next court hearing. But I'm going to give him a couple of months to show me what he can do on his own.
Okay, thank you.
Thank you very much. Any questions, Mr. Frost?
No, sir.
All right. Good luck to you. I'll talk to you in a couple of months.
Thank you. Thank you.
Next matter is Danny Marcinkowski and Stanley Huffman, file 17-16885-DP.
I have neither party.
Neither party is present. Ms. Kraus, have you had contact from Mr. Huffman?
I have not, but this hearing was adjourned from April 24th to address his compliance of him making the support payment of $536 or a commitment to jail. He has made payments in April and May. I guess I would just be, as payments have came in, just request to maybe adjourn out additional 3 months and adjourn in advance if he makes it, and then dismiss the hearing if the payments then continue.
So ordered. Jill Boges and James Boges, file 17-17094-DM.
I have neither party.
Neither party has appeared at the call of the court. Ms. Kraus, have you had contact with Mr. Bogus?
I have not had contact with him, but we did adjourn this hearing out in advance because he was in the Saginaw County Jail. So it was rescheduled to after his anticipated release of April 28th. Since that hearing, our office did prepare a recommendation in regards to addressing an ordered on arrears amount of $54.50. And then it would be the defendant to pay $163.50. The sum's composed of $109 for current support and the $54.50. The current arrears on this case is $11,328.07. I did check Otis and Vine for information. I really wasn't able to find that he was incarcerated somewhere at this time, so I don't really have any good information to provide outside of that.
All right. You've not received any objection to your recommendation on the ordered on arrears amount?
No, we have not.
All right, I will adopt your recommendation then as the order of the court as to the arrears amount. And last you heard, he was in the Saginaw County Jail?
Yes, Saginaw County Jail, and then the offender tracking information system indicated that there was supervision that started in Genesee Flint area on April 13th, but I did not have any good contact, or I left a message, but I haven't received a return call in regards to if he is or maybe is somewhere in regards to that probation.
All right, I'm going to ask you to make one more attempt at contact, either with the Saginaw County Jail or the Genesee County Probation Department, to see if they have any subsequent information. If not, I'm going to do a bench warrant with the normal 25% for failure to appear today. If he is in fact incarcerated, obviously no fault of his for not showing up today. But if you can't find out any information on him, please do the bench warrant.
Okay.
Thank you. Jennifer Hoyt, file 19-17760-DM. I do see Mr. Hoyt is with us. Ms. Kraus, can you update me on this matter, please?
Yes, this hearing was adjourned from February 27th to monitor the plaintiff's continued monthly support payments of $764 and good faith efforts towards overdue support March, April, and May. The hearing would be dismissed today if that was done. There was no payment received in April. May, there was a payment of $800. The arrears balance for this case is $19,799.27. I do believe the plaintiff would have some additional information regarding to potential payments that may be on hold.
Mr. Hoyt?
Yes, Your Honor.
What's
Good
your
morning.
response? Tell me about your attempts to make payments.
I currently have my tax return that is on hold pending my wife's, I forget what it's exactly called, but basically just releasing her portion of it. And it's a process. And I've also got a couple, well, not a couple other things. I have an insurance rebate that I'm waiting from that the state of Michigan currently has on hold that I've got to verify my identity 18 different ways before they'll release it. So I'm in the process of that as well. That's about another $800 on top of, I think, 25 or 2,800 or something like that for the taxes. But nursery season just started, so I'm getting back in the money area. So.
All right. Well, it sounds to me like you've been making some attempts at making payments. But I think you know as well that making attempts at payments doesn't actually pay the current bills. So I need you to do whatever is necessary to get these payments made. I'm not going to do anything today because it appears to me that you've made reasonable efforts. And you've made a single payment of $800, and there seems to be sufficient monies coming to put a dent in your arrearage amount. Where do you currently work at, sir?
Same thing.
Well, because I
Still-
have 800 cases, I can't always remember exactly
Oh,
where
I
everybody
apologize,
works.
Your Honor. I'm still an owner operator trucking
All
over the
right,
road.
thank you. Has there been a slowdown or a pickup? Which, what direction is your business going for the trucking business?
The most honest answer I can give you is whichever direction this war is going to go, because fuel prices are at a point we've never seen in the trucking industry. I can't even give you an answer. I have no idea which direction it's going to go. It seems to be okay. There's a thing called a fuel surcharge when fuel starts getting higher. So it is helping, but people have only got so much money to put into these loads. You know what I mean? So I'm
Well,
waiting for the
tell me what
background
you-
clearances.
Tell me what you've done the last 3 weeks.
Truck. Just truck. Run my logbooks
Okay.
down, truck, and just do what I can at home. I'm not even having any family time. I'm just trucking. I'm 70 hours a week in that cab.
All right, so there should be some, and that's where your payment came from this week or this month?
Yeah. Yeah.
All right. Well, you appear to be doing what you're supposed to be doing, which is put your nose to the grindstone and get at it.
That's
And
all I can do at this point, sir.
I appreciate that. So, we're going to adjourn this out for 30 days to see what the status of your insurance rebate and your tax return is. If those
Okay.
come through in that 30 days, I'll give the friend of the court discretion to cancel that hearing and bump it out another couple of months to make sure that you can continue to make your payments. And as long as you're making your payments, that's all I can ask you to do.
I think
You know
it's
that
going to
you're.
be at least, sorry, go ahead.
Go ahead, sir.
It's going to be at least another 60 days on the, just for the tax rebate or the tax return release, just the whole process. They said it was like 90 days or something like that. Cause I don't know. She's got to go get it notarized and this, that, and the other. I literally
right.
signed down here as you called my name. I'm just getting home, just getting situated here. So I'm sorry.
All right.
Your Honor.
Well, yes, go ahead, Ms. Kraus.
I was just going to indicate that Mr. Hoyt has been in contact with the friend of the court. We wouldn't be opposed to potentially adjourning it out to the end of August, as long as he's making some sort of a payment each month to allow time for that to process. We could set the hearing potentially for August 28th. If everything goes through and those payments are made, then we could just dismiss it because he has been in contact and has been prior to these hearings.
Does that sound like a good thing for you, Mr. Hoyt?
That sounds, yeah, a little opportunity here. I kind of feel like I'm back on probation and it's been a long time since I've been on probation. So a little time here would be great for the mental stability, you know?
All right. And again, it sounds like you've bought yourself some goodwill with the friend of the court by being in contact with them. So keep that up.
I'm just trying to be open and transparent. There's
Good.
no silly games
And
here.
So I hope that you can see that works. So we're going to do that. We're going to do what they suggest. We're going to bounce it out to August. We're going to give you some time to continue to do what you're doing, because it sounds to me like you are working hard. And I want to show you a benefit from doing that. So I'll see you in August. Hopefully things will go really well and we won't have any further problems. Thank you, sir.
Yes,
Have a good day.
Thank you, Your Honor. You too. Thank you.
Naomi Keaton and Brian Frazier, file 20-18252-DC. I do see Ms. Keaton is present.
Brian is as well, his video and.
Mr. Frazier with us as well. All right, I do see Mr. Frazier is with us as well. Ms. Kraus, could you update me as to this matter, please?
Yes, this hearing was adjourned from April 17th when the plaintiff bond was reduced to a PR bond with conditions. The plaintiff was to update her address prior to being released from the Otsego County Jail. That form actually was not returned, so we do need to get a good address for her. And she was to submit 10 weekly job searches. We did receive an email with 9 applications, but since then I've had contact with Miss Keaton in regards to, I believe she's appearing from Bear River Treatment Facility. Support has already been abated, And we are in the process of initiating a new support review. The balance for this account is $4,299.52. I would just ask for Naomi to present the information that she has.
Ms. Keaton, go ahead.
So I've been in treatment since, so I was in ATS in Traverse City starting on the 8th. I got released from there on the 11th of May. And then I had to wait for a bed here at Bear River. I got in here on the 13th. And then I'm funded until the 31st right now. And then I'm putting in for an extension on Monday. So hopefully I'll be able to get extended for another, I think it's 14 days at a time that my insurance covers. But I do, whenever I get out, released from here and complete, I do have a job at Kelly's Catering out of Traverse City. And then I'll be able to start making regular payments.
All right, thank you. Mr. Frazier, is there anything that you want me to be aware of?
No, I'm just learning what you're learning.
All
Yeah.
right. Does the friend of the court have any additional requests?
I guess given that information, potentially we maybe can adjourn this back in front of the referee to continue to monitor her, I'm not sure if it's drug or mental health treatment. And then continue with the support review upon the information we receive when she's out, as I'm not sure how long it appears that she will be there.
Ms. Keaton, is the employment opportunity that you had, Kelly's, I think you said it was, is that new employment for you, or is that going back to an old employer?
No, it's gonna be new employment. I just wasn't able to start until the beginning of May is when it picks up. So I'll be working with my sister. She's like the head person there. But I relapsed last month and I decided to check myself into treatment.
All right, I'm going to give you a chance to successfully complete your treatment. Once you are employed, you need to give that information to the friend of the court within 7 days. So the start date, within 7 days of that, you need to have that information to the friend of the court's office. Ms. Kraus, would you prefer to handle that in front of the referee, or do you want to continue to handle it in front of me?
No, I believe we can handle it in front of the referee, given the circumstances.
All right, then I'll refer the matter back to the referee for a determination then, once she gets started in her new employment, about what the child support amounts should be, and to monitor her payments on that new amount once it's established. And then if there is a failure to do so after a sufficient amount of time, you can bring that back in front of me if necessary. But let's try to get it back on track in front of the referee.
Yep.
All right.
And then,
It's never been on track.
Just
I wouldn't say back on track. I'm the only one that's ever put anything on track. So
Mr. Frazier, do you have a question there?
no, I was just wanted to, I don't know, said properly, because it wouldn't be get back on track. It would just be getting on track.
Thank
Times
you for
are
that
hard.
correction, sir.
Yeah,
I
sorry.
appreciate your-
Times are hard, and I've been doing this by myself for a long time while paying off $4,000 of child support that she's gotten, and all we got is a fucking Pikachu. Sorry, my language is a Pikachu. So, like,
Thank you, Mr. Frazier. Well, today's hearing is closed at this time. Thank you.
yes, sir.
We'll do it
Thank
as you requested, Ms. Kraus. That's all.
and just additionally, may I just ask that the order reflect that she contact friend of the court upon 72 hours of her release
Yes.
from treatment?
Yes.
Thank you.
Jason Trevorrow and Patricia Mobley, file 04-10782-DC.
I have neither party.
Neither party has appeared at the call of the court. Ms. Spillane, have you had contact from either of these parties?
No, sir, I have not.
We're going to address the issue of contempt and forfeiture of the bond. Could you tell me a little bit more about that, please?
Absolutely. Ms. Mobley had posted bond on April 21st in the amount of $1,700. It's an arrears only case with an ordered on arrears of $86 a month, and a current balance after the bond has been reflected would be $5,225.88. Payments have been non-existent since 2018, and we've not had any recent contact with Ms. Mobley. Given that information, I think it might be appropriate to issue another bench warrant.
I would agree with you. So we will forfeit the cash performance bond, apply it to the arrears, and then we will issue a new bond in 25% of the current amount that's owed in arrears. Anything else that you would ask for the court to order?
No, thank you.
All right, that's the court's order. Thank you. Kristin Izzet and Joseph Lier, file 09-13269-DS.
Joshua Lier,
I'm sorry, what did I say?
Joseph,
Joshua Lier, thank you.
he is present.
I do see Mr. Lier is with us. Ms. Spillane, can you update me on this matter, please?
Yes, sir. Mr. Lier has a monthly obligation of $186 plus an additional $50 ordered on arrears. His current balance is $9,504.18. Last payment was in May of 25 in the amount of $848.34, which was involuntary. Prior to that, it would have been September of 24 in the amount of $1,247.56, which was also involuntary.
Mr. Lier, what do you have to say for yourself?
Nothing. I've been taking care of her and everything. Kristin was supposed to delete it. She didn't even know we had court today. I just told her that we did.
I don't understand what you mean by you've been taking care of her.
I thought it was all taken care of out of court. This is the first notice I've had in years.
How would you believe it's been taken care of when you're $9,000 behind?
Just like I said, this is my first thing of getting paperwork in years.
Well, you had $1,000 taken from you in September of 24 and another involuntary payment in May of 25. Where'd you think that was going?
That was taxes. I don't never get taxes back. We're self-employed, so I didn't know that I was getting a refund.
You mean to tell me that you have no idea when thousands of dollars are taken out of your taxes?
I don't do my taxes. My wife and now we're getting divorced, so I don't do taxes. She does. Kristin is self-employed and so am I, and we've been communicating and taking care of every single bit of responsibilities.
Well, now you know, Mr. Lier, you're $9,000 behind. So what's your plan for making it up?
I'm going to talk with her and see if we're going to get it canceled out. And on here, it says that I had for insurance as well. She's had insurance through me and my wife for 4 years now. She has Blue Cross Blue Shield. Like I said, I didn't think I was behind at all. So
I don't understand what you're talking about for insurance, Mr. Lier. What are you referring to?
and it says for medical support, I have medical insurance on her.
Is that, Ms. Spillane, is that expenses of birth costs?
I believe he might be referring to being ordered to carry the insurance. I'm just gonna double check and see if I can find anything on that real quick.
The form on the third page of the motion in order to show cause has the box which says child support, medical support. That, you familiar with what I'm referring to now, Ms. Spillane? I think
Yeah.
he's referring to the $19 in medical support and the past due amount of $1308.88. Is that from costs of the birth? Or what is that from?
No, I believe that's healthcare expenses. I'm looking at the order right now, and it looks like both parents were ordered to carry insurance. So that might be part of what that is, but that's definitely something we can look at if Mr. Lier is possibly going to file a motion or get in contact with our office. We can look at doing a new review, which would of course take into account any kind of insurance expenses.
Yes, ma'am. I'll be in there first thing. Well, not first thing, because I know you guys are closed on Monday. That's my only business day that I have off.
All right, Mr. Lier, I'm going to ask you to contact the friend of the court's office as quickly as possible. If you need to file some motions in order to resolve some of these issues, please do so. I'm going to adjourn this out for 30 days to see where we're at. But as of right now, you still owe $9,000 and you haven't made payments, voluntary payments in a number of years. And that's got to change if there's going to continue to be a debt that's owed. So I'll give you 30 days to get things straightened out now that you know that there is an issue. And then we'll talk about it again next month.
No
Anything
problem.
else,
Thank you,
Ms.
sir.
Spillane?
I'm all set, Your Honor.
Thank you. That's all.
Thank you.
Good luck, sir. Jessica Lounsberry-Burns versus Jonathan McMurphy, file 12-14631-DS.
We have neither party.
Neither party has appeared at the call of the court. Ms. Spillane, have you had contact from either of these parties?
I have had contact with Ms. Lounsberry-Burns. This matter was adjourned from April 10th to monitor her newly reported employment and income withholding order. She has a monthly obligation to $256 with an additional $128 ordered on arrears. Her balance is $8,501.20. Last payment received was in March of 26 in the amount of $384. She had reported new income or new employment on April 2nd. She called me back on April 13th and said she changed jobs. And then again on May 1st, where she changed jobs once more. To my knowledge, she is still at that same job that she reported on May 1st. We do have an income withholding order in the works. It just has not become active yet.
What is your request given those circumstances?
I think given the circumstances, I'd like to give her benefit of the doubt and maybe just adjourn out to see what happens with this income withholding order.
Sounds like a good idea. Let's do that. Amber Tomcet and Michael Newton, file 13-15186-DP.
Mr. Newton is.
Hello?
Please put on your video, Mr. Newton. All right, I do see Mr. Newton is with us. Ms. Spillane, can you update me on his file, please?
Absolutely. This matter was adjourned from April 10th to monitor the defendant's employment status. You had instructed him that he needed to apply to 20 jobs per week and send that proof to our office. I did speak with Mr. Newton on the 19th of this month, and he said he was doing subcontracting at $15 an hour at 20 hours a week, which would account for him to be able to go to counseling and to schooling. I've also requested that he return some paperwork to us regarding a case questionnaire so that we can work on a support order.
Mr. Newton, is that correct?
Yes, sir. Yes, sir.
Tell me again why you're only working 20 hours a week.
Because because I'm trying to be enrolled in college and it's a little bit of a struggle. I got all my stuff turned in for that. I'm trying to get into college and I'm trying to leave hours available for me to be able to do that with working, reporting, going to counseling, taking care of the house. I'm just trying to manage everything in a way to where I can do it all. And I believe I can start making payments because I'm trying to finish paying off my Gladwin County friend of the court. I only had $3,000 left on that. And then my fines here. So I'm doing everything I'm supposed to be doing. I want to work more, but I have to leave hours available to be able to get a better job by going to school. I'm trying to get into school for welding so that way I could get a better paying job.
So are you in school or not?
All right, so I've been accepted to mid. I've got approved for my FAFSA 2026, but I got hung up on it because apparently I have to do a 2025 FAFSA, even though it's not 2025. I don't know why I have to do that. So I am accepted in there. I'm not. My classes haven't been registered yet because I have to finish this other FAFSA form, so I have to go up there to get some assistance because I'm struggling trying to figure out what all I have to do. There's a list of things I have to do, like to get my transcripts. I've done that. Do so much, get my all my information about me. I've gotten everything, all my identification, my transcripts, my FAFSAs filled out, my Michigan Reconnect filled out, and it's still saying that I have to go back and do something from a year that doesn't make sense to me. So I just have to get up there. But I am a student. I'm just not registered into any classes yet, which I'm working on.
So the answer is no, you're not going to classes.
Not yet, yes.
So why would you need time off of a work schedule when you're not actually going to classes?
Because I was supposed to start this month, but because my 2025 FAFSA, I didn't get it filled out, I have to get my tax returns back for them to finish it. Other than that, that's why. I mean, I'm constantly working. I'm constantly doing something good. I'm doing stuff all the time. I work, take care of my house, take care of my family. My son's mother just died, so I'm taking care of my 18-year-old kid who's having troubles. I have to have hours to do stuff like that,
Ms. Spillane, could you tell me his payment history, please?
Yes, sir. So the balance on the case right now is $7,042.45. We're in the works of reinstating support because it was abated due to incarceration and the rehab. Last payment we received was in February of 25 in the amount of $20. In January of 25, we received $20. In November of 24, we received $20.
To your knowledge, when was Mr. Newton out of jail and out of rehab?
I believe that would have been in March.
March 5th.
Yes, that's correct.
When did you start working, Mr. Newton?
Probably about 3 weeks ago.
Ms. Spillane, remind me again of his monthly obligation, what it currently is.
Right now it's abated. Previous to the abatement, it was $205.
Why is it still abated?
We're in the works of doing a support review. Support will reinstate. July of 2026 is when it should start back up again because of the rules with incarceration. We're supposed to give 3 months after they're released.
I do have a question about that though. Am I able to, like right now, for instance, I have money. not very much, but am I able to go to the courthouse and start making payments, or do I have to wait till the abatement is lifted?
You can make payments anytime.
Oh, okay. Okay,
Yeah.
okay. Well, that's all I've been waiting on. So I know I can start making payments. Because I gotta do it a certain way. I have to pay you guys, Gladwin, Claire, and here. And I'm getting everything caught up to the best I can, and I'm trying to do this and succeed. You know, I'm still sober, living the best life I've lived so far. And I just want to get this stuff all took care of. You know?
All right, Mr. Newt, I'm going to give you a chance to work things out as you feel they are best done. I got to tell you, if you're not in school,
Okay.
you need to have more hours at work. If
Yes,
you're
I
at
do.
school, I can if you're actually going to classes, I can certainly understand that's a priority. I can understand that. But when you're not actually in classes, you got more opportunity to work. You've got a deficit here. You're $7 grand in the hole. You need to be making payments and working hard. So I'll leave that to you. Ms. Spillane, let's do this in August, have a set of review hearing in August. If that'll give you time to get a support recommendation out. And we'll see what happens after his period for July is done and over with. So I'm going to give you some time here, Mr. Newton. Please impress me. All right.
Much. I appreciate it.
That's all for today. Thank you.
Thank you.
Brent Marshleski and Don Crow, 14-15388-DC.
Dawn is here under Dawn Ryder.
I do see Ms. Crow/Ryder is present with us. Ms. Spillane, can you, or just Ms. Krause's case, which one?
We each have a case with her.
All right, let me find the other one then.
No. Not this one.
Okay.
All right, Ms. Spillane, which one's yours?
I have the one with Mr. Marchluski.
All right, I've called that one, so let's do that one first. Can you update me on that, please?
Yes, I can. This matter was adjourned from April 10th. The defendant was not present at that hearing, and we had adjourned to monitor her mental health treatment. She has a $51 a month obligation with a balance of $2,459.81. Last payment received was in January of 26 in the amount of $125. We did have contact with Ms. Crow yesterday, and she did speak about applying for Social Security disability. Given some of the information that she shared with our office, I think it might be appropriate to adjourn this to the referee to monitor the status of her Social Security disability application or proof of that, and then also request that she supply an ability to, I'm sorry, like a physician's form indicating her ability to pay or not pay.
Did you discuss that with her at your meeting the other day?
I did not speak with her directly on that. That would be Ms. Krause.
All right.
I did, Your Honor.
All right. Let me call the other case as well, so we can hear both of these at the same time. This is Don Crow and Jason Fennell, 23-19387-DS. Ms. Krause, from your perspective, can you update me as well?
Yes. Additionally, it was adjourned from April 10th. The plaintiff monthly support obligation is $311 for this specific case with an arrears balance of $4,394.49. I did have the conversation with Ms. Crow. She had indicated that she had applied for Social Security disability on April 19th. At that time, I did request proof of the application to be submitted to our office. And then additionally we would mail out a medical needs verification with the order from today and request that she submit that. So then we can address that application and her ability to pay and earn income at a later date in front of the referee.
All right, Ms. Crow, you've heard what the friend of the court workers have said. Is that what you want to do?
Yes, sir.
All right, do you understand your obligations to provide the medical information that they've asked for?
Yes, sir.
All right, I'm going to give you some time to be able to do that, and we'll reset this in front of the referee once the friend of the court has received that medical information, and he'll make an initial determination of what to do with your child support at that time. And if there's any need for an appeal or review after that, I would have that afterwards, but we'll send this all to the referee in both of these cases. Do you have any questions, Ms. Crow?
I do not, sir.
Anything else from the friend of the court?
I would like to make the court aware during that conversation, Ms. Crow did indicate that she is not currently living with her mom, but she can receive mail there. So I just want to make sure the court is aware that we did have a conversation that she's responsible for obtaining that information if she doesn't get the mail.
You understand that, Ms. Crow?
Yes, sir.
If you want the friend of the court to send you mail at a different address, you are responsible for providing them with that address in writing. So if there's going to be a change, it has to be done by you on a form in writing to the friend of the court so they know exactly where to send it. Otherwise, they're going to keep sending it to your mom's house and you're responsible for picking it up there. Do you understand?
Yes, sir.
All right. Then we'll go ahead and allow the referee process to occur. Anything else from the friend of the court?
No, thank you.
No, sir.
No, sir.
All right, that's all for today. Thank you, Ms. Crow.
Thank you.
Ashley Bagby and David Losiecki, file 14-15600-DP.
Both parties are present. Ms. Bagby does not have her camera on.
Ms. Bagby, could you start your video, please?
Yes, hold on one.
All right, I do see Ms. Bagby is with us. Mr. Losiecki is with us as well. Ms. Blaine, can you update me as to this matter, please?
Yes, sir. This matter was adjourned from April 24th to allow the plaintiff time to seek mental health treatment. And that it was discussed at this hearing today, the court would address the plaintiff's payments going forward.
Ms. Bagby, how are you doing on your mental health treatment?
I'm doing much better, Your Honor. I am relocated to a live-in facility. I get therapy 4 times a week. I also have 2 jobs now. I work with my former boss on Wednesday, Thursday, and Friday, cleaning in Petoskey, and I just got hired last Monday at Duffy's, downtown Petoskey, where I will be bartending and waiting table 4 days a week.
Ms. Blaine, what is her current monthly requirements?
She's to pay $388 per month, and the current balance is $21,033.17. We did receive $650 last month.
Prior to that, what did she pay?
In March, she paid $500, and in February, she paid $619.
All right. Mr. Losiecki, as to the payment amounts, have you been receiving those?
I do believe I have, sir.
All right.
It comes in on a card, and I just use that every once in a while when I take Brixton somewhere, or Walmart, or somewhere like that.
All right. So it looks like she's made payments, substantial payments the last 3 months. Still haven't got this month worked out, but she's got a job and the availability of those things working this month. So it sounds like things are getting on track for Ms. Bagby. I want to continue that upward trajectory. I think I'm going to continue to do these monthly meetings because they seem to be working to get the payments made. So we'll do that for a few more months. Ms. Bagby, if you can give me 3 months in a row again, where you have made your payments on time. Now they've been a little bit stop and start, but you've been making them. But if you can make them on time, I will, at that point, after 3 months in a row, consider not having to have you show up every month to do this. But I need to have some consistency in your payment schedule. Do you think you can do that for me?
Absolutely, Your Honor.
All right. I'm glad to see that you're doing better. I'm glad to see that you're making payments on time. It appears good that you got some jobs lined up for you. That's always a good thing for you. So we'll see you again in a month and continue to do the good things that you've been doing so far. Thank you very much, ma'am.
Thank you, Your Honor.
Amanda North and Michael Taylor, file 17-16988-DM.
I have neither party, Your Honor.
Ms. Spillane, have you had contact from either party?
Not recently.
All right, neither party has appeared at the call of the court. This was a show cause set for today at 9:30. It's now 10:11 a.m. Notice went out to the defendant on April 14th of 26 from the friend of the court's office. He failed to appear. We'll issue a bench warrant. What is his arrears amount?
His balance right now is $2,319.06.
Let's do the statutory 1/4 amount of that as the bond on the bench warrant. Katie Kirk and Jacob Moore, file 18-17137-DS. I do see Mr. Moore is present. Ms. Spillane, can you update me? Yes, I see you, Mr. Moore. Thank you very much. Ms. Spillane, can you update me on his matter, please?
Yes, I can. The defendant was adjourned from April 8th at the referee hearing, and the referee had recommended contempt given the length of time since the defendant had last paid and his ability to pay from available resources. He did give him the option to pay $1,200 prior to the hearing or provide a physician's note stating he was unable to work during the periods of non-payment. I did speak with Mr. Moore, and he had indicated to me that he was in treatment between May 12th and May 19th, and we did receive a physician's note indicating as such. He has a $140 a month obligation with a balance of $2,384.38. We received $11.27 this month, and for last month, we received $134.43.
Mr. Moore, why haven't you been making your payments?
I was working at Meyer part-time. It wasn't paying the bills. It wasn't making things right. And a job opportunity came arise where I just moved back to Traverse City for a better job as a heavy equipment mechanic. And I just got everything in order. I do plan on making bigger payments, but excuse me, I just, life has been kind of torturous, and I've been trying to get better at making payments and trying to find a job that actually will be able to pay my bills and everything. And I did, and I was going to start, and then I wound up getting treatment, and I'm just starting this job.
So who are you working with now?
J&T Concrete in Traverse City.
When did you start there?
I started about a week and a half, 2 weeks ago, but it was only a few days in, and that's when I went to go seek some mental health treatment. And I just got out the couple, 3-4 days ago, and I am starting work at J&T Concrete. It's just a matter of getting my first paycheck.
Were you given your information about JT Concrete to the friend of the court's office?
No, when I called the other day about the physician's note and everything, I was planning on telling him about my move and the new job, but I honestly, it just slipped my mind.
You do recognize that the referee has sent this case to me to decide whether or not you should be held in contempt of court, which means a decision on whether or not I should put you in jail. You understand that?
I do understand, sir.
Have you done everything in your power to try to stay out of jail?
I have. There is no excuse for me not making payments. I know I should be making bigger payments or trying a bigger attempt. It's just I haven't been able to, and I don't really have any excuses other than that. I've been trying.
So what do you consider to be trying? What specifically have you done to make your payments?
I just didn't have the funds. I was working at Meyer part-time, and between just everyday life things of gas, I don't even have insurance on my truck, and food, and I have three friend of the court cases to try to make payments for, and I had to, for Montmorency County, I wound up having to pay a very large sum. Otherwise, I would have had a warrant put out for my arrest, and I'm splitting hairs here, and I know I could be doing more, and that's why I took this job and to move, because I wasn't being able to make the bills paid and working part-time at Meyer. So I took this big jump and leap for a heavy equipment mechanic to be able to actually pay these fines and bills that I need to pay.
All right. I'm going to give you a chance to have this new job work for you.
Okay.
But you're going to be back here in a month, and I need to see money at the friend of the court's office as much as humanly possible. Do you understand what I'm saying to you?
Yes, sir.
All right. So we're going to adjourn this out for 30 days. I'm still looking at whether or not I should send you to jail or not for contempt of court. So I'm giving you a little bit of leeway here to give you time to prove to me that I don't need to send you to jail. So
okay,
act accordingly.
Yes, sir.
Ms. Spillane, is there anything else that you would need?
Yes, sir. He indicated that he had moved. I still show a Gaylord address. Would it be possible to have him update that if he's not comfortable saying it on the record right now? If he could, call in and you order us to update that.
I can get the address over here. I'm fine with giving the address over this.
Go ahead, sir.
It is 11584 South Cedar Road, Cedar, Michigan, 49621.
Thank you.
You're welcome.
Ms. Spillane, just for the court's records as well, would you send that to the county? Well, Ms. DeFighter, did you get that for the county clerk's records?
I didn't get the street address.
It was 11584 South Cedar Road.
And then you said Cedar, Michigan.
Correct.
And what was the zip code again, sir? I'm sorry.
49621.
Thank you, sir.
You're welcome.
Thank you, Mr. All right. That way we can make sure we get notices to you if necessary from the court's system as well as the friend of the court system. All right, so we'll adjourn this out for 30 days. I want you to make your payments and make some payments towards your arrearage amount as well. And then we'll discuss where we go from here once we get to the next hearing. So that's all for today. Thank you, sir.
Thank you.
Your Honor, as of 10/18, Mr. Taylor has popped into the Zoom. He was your last case that you entered a bench warrant on.
All right, thank you. Court will recall the matter of Amanda North and Michael Taylor, file 17-16988-DM. Is Mr. Taylor present, please?
Yes, I am, Your Honor.
Mr. Taylor, we actually called your case about 5 minutes ago. You're supposed to be here at 9:30. What happened?
I'm in Oklahoma City and my phone, there's an hour time difference. Like right now it says it's 9:20. I forgot about the time difference.
All right, I'll accept that as a simple mistake. So no harm, no foul. Ms. Spillane, can you update me as to Mr. Taylor's matter?
Yes, sir. This matter was adjourned from the referee's hearing on April 8th with the recommendation for contempt, given the length of time since his last payment. And he also gave him the option to pay $1,500 prior to today's hearing to cancel the hearing. His monthly obligation is $290 with a balance of $2,319.06. Last payment received was in November in the amount of $2,000.
You guys should be receiving payments from me
Why do you believe that, Mr. Taylor?
because they're coming out of every check.
Ms. Spillane, is there any documentation that you have that corroborates that?
Nope, the only thing I can see is the last payment in November. Let me check and see what's going on with the income withholding.
I was gonna say, you guys sent the income withholding and they've been taking the money out of my checks every week.
That may be the case, but I don't know if they've been sending it in or if there's issues with how it's been sent in. Because we have not received anything from the employer yet.
How long has there been an income withholding order in place?
Mid-April.
All right, Mr. Taylor, you are now aware of a problem. At our end, we're not getting the money. It may well be coming out of your check, but apparently it's not being sent in, or if it's being sent, it may be being sent to the wrong place or with wrong information on it. So we need you to check with your employer to find out where that money is being sent so that you can report that information to the friend of the court so that we can not try to hold you in contempt of court.
All right.
Ms. Spillane, is there anything else specific that he needs to do to rectify this problem?
If he's able to provide pay stubs to show that it's been coming out, that would be helpful as well.
I can email copies of all the pay stubs that show that, like it says, I got an escrow of $250 coming out, and then it says FOC obligation or something like that, and it shows, you know, my child support with extra for the back child support that's supposed to be coming out every week.
Let's do this then. I'm going to give you 30 days. We'll set a new hearing next month. I want you to email copies of your check stubs to the friend of the court's office to verify what you just told us. And then I want you to have a conversation with your employer, their HR department or their finance department or payroll, about the income withholding order and where it's being sent and what's being done with that. And then I want you to email or have a conversation with Ms. Spillane about that as well, so that we can figure this out. If Ms. Spillane and you can get things working with the income withholding order, I'll give her the discretion to cancel next month's hearing in advance. If we can't get it settled, then we'll have the hearing and I'll make a decision about what to do. But it sounds like it's just some administrative problem, and hopefully we'll be able to get the money flowing and everything will work well after that. Any questions that you have, Mr. Taylor?
Not at this time, no. Like I said, I'll get a hold of Tom as soon as I'm done here at my niece's graduation and find out what's going on with the child support that they're taking out of all my checks. And I'll try to get everything emailed over to Miss Spillane today if I can.
That sounds good, sir. I appreciate that. We'll set a hearing for next month and we'll see how it goes. Thank you.
All right, thank you.
This is a request for a order to show cause by Mr. Ingersoll against Ms. Varen on a parenting time complaint. Mr. Ingersoll, do you want to tell me what your complaint is, please? You're on mute, Mr. Ingersoll.
How's that?
I can hear you now. Go ahead, sir.
All right. So today I'd like to ask the court to modify the existing order due to
That's not what we're here, Mr. Ingersoll. Mr. Ingersoll, that's not what we're here for. You filed a complaint about parenting time. That's what's scheduled for today. That's what we're going to do today.
All right. What was your first question? You said what happened?
My question is, tell me what the complaint is.
My complaint is that on multiple occasions while being down there to visit, my daughter's mom has said wildly inappropriate things to me in front of our daughter. She has cut my time short. She said she's going to run me over. I just think that some of the things that have been said are extremely inappropriate, and I think that she's just got a lack of ability to control her emotions and feelings because of the things that she says. And I think that being around her during these visits is a distraction to the parenting time. So what I'd like to know is the next time I go down, if she's not available, like last time, like we had a great visit last time, but I did wait in a parking lot for 2 hours waiting for her to get home because she would not allow her mother to meet me for breakfast because she wasn't a part of the approved people. So can we change that as well?
Mr. Ingersoll, I told you that we're not here on a modification of the court's order. We're here on a complaint that you filed saying that there was a violation of the court order. What violation of the court order are you complaining about?
Well, I sat at a gas station for 2 hours waiting for her when she knew I was coming down. Like we had a great day, but I still I thought we agreed on a time, and I drove 10 hours to go down there, and it was a great day, but still, like if that's what you want me to complain about, like that's my complaint is, I don't know, the things that she said in front of my daughter. Like I don't think that her conduct is appropriate.
Mr. Ingersoll, what part of the court order do you think was violated?
My time.
Please point out a specific part of the court order that you think gives you a specific time.
All right. In that case, then I guess I just want to withdraw my motion because clearly I'm not being heard. It's fine. Can we set a date for July, Your Honor, when we're supposed to revisit? Like, can we do that while we have everybody here?
A review hearing has already been set for July the 10th at 1:30 to review the parenting time that was to occur before then. So that's already been done, sir.
All right. I wasn't made aware of that. All right. Thank you.
It's in the court order, Mr. Ingersoll.
My apologies for not seeing the July date, Your Honor.
All right. That's all for today then. Thank you.
Thank you.
Next case is Madeline Warren and Tyler Warren, file 25-20287-DM. Set for a pretrial conference today. Counsel, you know, put your appearances on the record, please.
Good morning, Elliot Blumberg on behalf of Madeline Warren, who's appearing via Zoom from my office.
And Zach Backlund on behalf of the defendant, Tyler Warren, who is also appearing by Zoom this morning, Your Honor.
All right, I see that there's a referee hearing set for next week on the 27th in regard to a parenting time issue. And then I believe that there's been a recent objection filed to the child support review, so that matter would go back to the referee as well. Is there anything else outstanding that needs to be addressed, gentlemen?
Yes, Judge, there is. We appeared before you last month in a motion to maintain the status quo. You had originally denied our ex parte request for that motion. at the hearing last month, you suggested that the attorneys get together and see if they could work out what bills would be paid by Mr. Warren, which bills would be paid by Miss Warren. That conversation has been either non-existent or unsuccessful. I've refiled the motion because there are tons of medical bills arising from the birth of the two children. There are medical bills of my client, their mortgage payments, and frankly, we don't know at this point what Mr. Warren's prepared to pay without the court's order.
Mr. Backlund?
We started those conversations, and prior to the last hearing, I had sent what Mr. Warren is paying and sending and reflecting the invoices on certain utilities and half of the mortgage associated with the home. I've asked for the invoices or the bills of what else needs to be paid, and so I'm assuming those would be incoming from Mr. Blumberg or his client, so we know what's being asked in terms of the bills that need to be covered. And so that's required in order for that conversation to go forward. If it needs to go in front of you, Your Honor, I understand that. But, my hope is that Mr. Blumberg and I could work that out on our own if we have all the cards on the table in terms of what these parties owe each month for the bills.
Didn't I ask you to have that conversation last month?
If you're directing that to me, yes, you did. And we started the discussion, and my understanding was, and again, if I'm wrong, I'm sure I'll be corrected, that Mr. Backlund would be getting back to me. The parties had lived together. They know what the bills are. There are new bills for medical expenses that need to be addressed before they go into collection.
And I spoke with Mr. Warren about the medical bills and his understanding that those were paid before he left the house. So I don't know what the current medical bills are, and Mr. Warren doesn't know what they are if they haven't been paid off. So
we'll provide them to you again. I mean, I just don't, I mean, I'm sorry. I don't want to sound rude or overbearing, but these are marital obligations that need to be paid. We're not talking about beauty expenses or clothing for my client. We're talking about monthly bills that everybody knows are there.
Do I need to order the parties into mediation to resolve this issue?
I don't know that that's necessary. Mr. Backlund and I have a good relationship. I don't know why we can't get it resolved ourselves, but it really does need to be addressed sooner than later.
Yeah, my hope is that Mr. Blumberg and I have worked together many times, and my hope is that we could continue to do that, without waiting for mediation. I understand if the court wants to require us to go, but I understand that takes time to schedule. And then I'm acknowledging Mr. Blumberg says time is of the essence here, and I don't disagree with that. And I understand that there are marital bills that need to be paid. And hopefully if we're able to do that quickest between the two of us, that would be the way to get it done, Your Honor.
I'm happy to allow you to do that, but it didn't get done last month. And I believe if I ordered you to mediation, I can get you into community mediation probably this month or within 30 days. So you tell me, do I need to order that, or are you guys going to get it done?
We'll get it done, Judge. I mean, we don't need a mediator to discuss what bills are bills. I mean, I don't think there's.
I agree with you.
So
I agree with you, but it makes you both be at the same place in the same time.
Fair enough. Yeah.
We'll get it done. I just want everybody to be on the same page about the importance of it.
All right. So is there anything else that I need to issue by way of a pretrial order coming out of today for this case?
There's one other, I guess, issue that I think perhaps the court can help us with. It's historically, Mr. Warren has a military obligation that would take him away from the home for an extended period of time. We have asked for the dates of that so that we can address parenting time issues in his absence. We have not received that, nor do I anticipate getting that without a court order. I think it's appropriate, given the fact that the parties share both physical and legal custody, that his military schedule be provided.
Mr. Backlund?
I assume Mr. Warren could provide that to me. I believe that that would be something scheduled well in advance, so he would know when that's coming. So I can get that from him and provide it, Your Honor.
Can we do that within the next 30 days?
I believe so, Your Honor. If not, Mr. Warren, chime in here in terms of when that's available, please.
Yes, I can do that.
Okay, thank you.
All right. I'm going to set another pretrial. The two issues at the front of the court should be resolved, I believe, in the next 30 days. So I'm going to set another pretrial in 45 days. If the parties can resolve this matter before then, submit the documentation and ask for a court date, and let's get it done. If not, I'll see you again in about 45 days. Is there anything else that we need to do today, gentlemen?
No, Judge, just I suspect that discovery will be open until such time as it closes. We really don't have any dates that are, if the court doesn't mind allowing it to just be open, Mr. Backlund and I can, I think, agree to that.
I would agree with that if the court would allow it.
I will. I want to encourage you guys to work together. So if it needs to do that, that's fine with me. So, all right, I'll issue a pretrial order with all of this on it, and I'll see you both in approximately 45 days. Thank you.
Your Honor,
Thank
that
you.
date will be July 31st if you want to give that to them.
July 31st, what time?
We can do another 10:30.
July 31st at 10:30 would be the next pretrial.
Okay, very good.
That works.
We'll send out
Thank you.
notices. Thank you.
Okay, thanks.
Ashley Hofstra and Kyle Wilson, file 19-17865-DS. Have the appearances of counsel, please.
Good morning, Your Honor. Elliot Blumberg on behalf of Ms. Hofstra, who's appearing via Zoom from my office.
Morning, Your Honor. Joel Shaw on behalf of Mr. Wilson, who is on Zoom at my office.
All right, I do see Mr. Wilson is with us and Ms. Hofstra is with us as well. This was set, I believe, as a review hearing for the court's previous order after de novo custody hearing. And then I believe that there's been a motion to modify parenting time. I don't know if that's scheduled in front of me or not. Mr.
It
Shaw,
is
as to
not.
that. All right, I'll just wait on that then. So, Mr. Blumberg, I'm going to go ask for your review analysis at this point first, and then I'll go to Mr. Shaw, and then I'll hear the parties if there's any need to do that. So, Mr. Blumberg, from your perspective as to how things have been going on the following the court's order.
Well, there have been some issues in regard to the exchanges, which I believe is the subject of Mr. Shaw's motion pending before the referee. Katie McMasters is the child's therapist who is, there she is. If she could be allowed in, she could probably give us an update.
She is here now. Ms. McMasters, good morning. This is Judge Hesselink. We're here on the Hofstra and Wilson matter. Mr. Blumberg has indicated that you are the therapist for the child. And could you tell me how things have been going from your perspective?
Yes, things are going well. She's doing well and she's opening up more. She has progressed in being more comfortable and being more open in sessions.
What is your plan moving forward with her as far as how often you meet together and the length of the time that you're going to continue to meet together?
I plan on still continuing. She's got she still has reservations, but she's doing very well. I meet with her about a half hour every week or I think it's it's supposed to be every week. So I'm going to continue that as long as her mother and father are fine with that. I think she needs it.
Thank you. Part of my court order was if you deemed it appropriate, deciding whether or not to have joint counseling with the father to address any issues that you thought might be appropriate for that. Do you believe that joint counseling would be appropriate or not?
I would like to stick with individual counseling just for the child, but like, I don't mind bringing him in for updates on the progression of the sessions.
All right. Have you talked to him at all up to this point?
I have one time.
All right. Do I need to do anything to assist you in that process? Or are you able to handle that all on your own?
Nope, I can handle that. I can contact him and get him in for another update on sessions.
All right. Thank you very much for being here. I appreciate that. Mr. Blumberg, do you have any questions for Ms. McMasters?
I don't believe I do, Judge. I guess I'm just, if I might, Ms. McMasters, the concerns that the child has in regard to being sleeping by herself at her father's home, is that an issue that she talks about or something that is still a concern of hers?
That is still something we are working on. It seems to be improving slowly, but there are some concerns there still.
Okay. Has she said anything at all about these exchanges when she leaves from her mother's to her father's and the return? Has that been an issue discussed at all?
She has not brought those up to me, no.
Okay. I don't have any other questions, Judge. Thank you.
Mr. Straw, do you have any questions for Ms. McMasters?
Just quickly, Ms. McMasters, can you give us a sense generally what it is that you and the child are working on?
We work on her feelings and instances that have happened and scenarios like what she experienced, I guess, is what she focuses on. She gets worried that people will get angry and there will be fights.
Okay.
So we talk about things like that.
And you said that you're counseling with her on a weekly or something close to that?
It's a half hour. It was weekly. There's been times I've had to cancel because of my own personal issue or field trips for kids, but most of the time, yes.
Okay. And when you characterized her as opening up, was that in regards to her opening up kind of with you as a, for lack of a better term, a stranger, or opening up about something specific?
No, that's just her like opening up to me, knowing can talk to me about anything, and she's building a rapport where she knows I'm trying to help and she can tell me how she feels and what she feels about things.
Okay, thank you. That's all I have.
Okay.
Thank you, Ms. McMasters. Appreciate your time here today.
Yes, thank you.
Mr. Blumberg, anything else that you want to bring to my attention?
I don't think so, Judge. I think that the situation seems to be settling down. Certainly the incident that brought us before the court some months ago hopefully won't happen again. I would hope that if Mr. Wilson could talk to the child's therapist, that would be beneficial for everybody, but I don't know if he feels there's a need to do that or not.
All right. I want to hear from Mr. Straw now, and then I'll ask both sides for their recommendations going forward. So, Mr. Straw, from your perspective, how are things going?
Well, I'm relatively new on the case, Judge. From my perspective, or I guess my understanding is that the incident that brought this matter before the court occurred approximately a year and a half ago, and there was an outburst by my client that stemmed from a confrontation with Miss Hofstra's boyfriend. I know he recognizes that he made grave error in judgment that incident a year and a half ago. But what I'd like to see the court do is essentially return him to the type of parenting time that he had before, which was weekend visits, overnight visits on every other weekend. And in regards to the motion to modify parenting time, Mr. Blumberg's correct. It relates to the exchanges of the child and trying to keep those more tempered by way of only having the parties present to do those exchanges. I don't care if they still happen at a public place, but I think that if it were just the parties exchanging the child, that would improve these exchanges fairly significantly. Another alternative that I've discussed with my client is if the court would consider doing a Friday after school until Monday when school starts, then the parties wouldn't have to interact with each other at all in the short term. Obviously, we're running into a situation where school is about to be released for the summer break, but I think that that might aid the parties in their dealings with each other. As I understand that Mr. Wilson and Ms. Hofstra can cooperate fairly easily together. It's when third parties get involved. So again, my request for the court, now that we're a year and a half down the road, my client is counseling individually, the child's in counseling individually. I think we can revert back to something closer to what was previously court ordered for the time being.
Mr. Blumberg, what would you like to see done?
Well, I would be most interested to learn about how Mr. Wilson's counseling is going, or who he's counseling with. I mean, the court will recall the video and the concerns that everybody had, and I'm certainly hopeful that that type of behavior isn't likely to happen again. But I don't know, maybe we could hear from Mr. Wilson in regard to the frequency of his counseling and how that's going and what's being addressed.
That's fine with me, Judge. If you want to put Mr. Wilson under oath, I'll give some brief testimony from him.
Mr. Wilson, if you'd raise your right hand, please. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Schroff, go ahead.
Thank you. Kyle, you understand that the reason that this matters essentially before the court today relates to an incident between you and Ms. Hofstra's boyfriend in December of 2024, correct?
Correct.
And your behavior during that incident, do you believe that it was appropriate or inappropriate or something else?
Highly inappropriate. Absolutely. Certainly considering the setting in front of other children.
Okay. As you heard Mr. Blumberg say, and probably the court and myself, we're all interested to hear about your individual counseling. Can you tell us what you're doing in that regard?
Certainly. Thank you, Joel. And actually, I was going to have my therapist, whose name is Stephen Wallace, I was going to have him in contact with you before today, but it was just too short of a notice of me getting in contact with him because he requires me to sign a release form in order for the two of you to speak. But maybe I could get that done today after I leave here. I've been going bi-weekly to see Stephen, and we've been working mostly on, impulse control during heightened states of emotions in those situations, such as, the one that I found myself in a year and a half ago with Matthew Sargent, and controlling those impulses and not allowing myself to internalize other people's actions and behaviors, and by default, not letting that influence my actions. I am so apologetic about what happened that night, all that time ago. I cannot take it back. The best I can do is move forward and not have any repeats. Really what it is that Stephen and I think, as far as terminology is concerned, are working on is cognitive behavioral therapy, which is mostly just kind of analyzing situations in real life, in real time, and then, asking myself why I'm feeling how I'm feeling, where that's stemming from, where that's rooting from, and what to do with those feelings in those moments of heightened states of emotions.
Okay, you're meeting with Stephen every other week. How long are your sessions?
They are 30 minutes.
Okay, and how long have you been working with Stephen? Do you know?
Probably the last 3 years.
Okay. Has it always been a every other week session schedule?
No, sir. I've ramped the session frequency up because of the severity of the situation that we're currently in here with the courts. So that's just me individually doing the absolute most that I can within reason of frequenting my therapist. It's in the world of therapy, that's a lot. Usually it's a monthly thing. So bi-weekly is about the most that I could get in there.
Do you feel that you have benefited from your therapy sessions with Stephen?
Yes, he is one of few people that in my life I feel like I can actually open up to in a genuine manner. So it's just a very healthy situation.
Has it improved your impulse control?
Certainly.
Do you have a fairly good working relationship with Miss Hofstra?
Yes, sir.
You heard my statements in regards to third parties and their involvement in exchanges of the child. If that situation where there's other third parties involved that the court doesn't have jurisdiction over was somehow corrected so that it would be just you and Miss Hofstra engaging in these exchanges, or using essentially the school as an exchange hub, do you think that that would be an improvement overall?
I certainly do. Either of which would both be an improvement, but certainly the greatest, I think, option of the two would be involving the school pickup and drop off.
All right. And you do have relatively frequent contact with your daughter, although the duration's fairly limited, on Saturdays or several Saturdays per week. How are those visits going?
The visits are good, and like you said, they're short, so they're very brief. But my daughter's happy. She has certainly, as Katie has put it, has improved. She seems to have kind of leveled out. She's playing well with other children when we go see Celeste's grandkids and other stuff. So she's interacting in a healthy manner. I don't see anything that seems out of sorts. She's very happy and comfortable with me and everyone around.
Okay. Do you foresee any issue expanding to something close to what you had before in regards to overnight parenting time?
No, I do not.
Okay. Thank you. That's all I have for Mr. Wilson, Judge.
Mr. Blumberg, any questions?
Just have a couple. Mr. Wilson, the counseling you're receiving, if I understood your testimony, has to do with impulse control. Those weren't just the issues that were of concerning to the court. There were postings that you had where you had a gun, or at least whether it was real or a toy gun, that were rather threatening, and you had talked about doing yourself in, that you didn't have any reason to live. Are you addressing any of those issues in your counseling?
Well, I believe the way you just presented all of that information was skewed. I have spoken with my therapist about all of those things and about how the context of all of those situations was skewed. But he understands what I'm going through, and we're just kind of doing our best to do everything in a genuine manner and not just jumping through hoops for the court's sake. So in short, I have brought all of those concerns up with Stephen Wallace, yes.
Did you share those postings with him?
Yes, I did.
So I think you've acknowledged that you've been seeing Mr. Wallace or Dr. Wallace, whatever his credentials may be, for 3 years now, but it's only recently that you've been going on a regular basis. Is that correct?
Yes, sir.
Okay, and that frequency is once a week for 30 minutes?
Once every other week for 30 minutes.
Okay. And you think that that's a sufficient amount of time?
I do.
Do you have some sense that Ashley feels a bit intimidated by you, and that if these exchanges were simply you and she might feel uncomfortable given what she's witnessed in the past?
I do understand that.
Okay. And you mentioned Celeste. She's your significant other that supervisor visits. Is that right?
That's correct.
Okay. Is she the one that does the transferring at all, or is it exclusively you?
She has been doing the transfers.
Okay. So when you file a motion and ask that no third parties be involved, it's not you that's doing the transporting. It's your girlfriend, right?
I believe if the court decides that we need to make that modification here today, that I will be the party doing the pickup and drop-offs in those situations. I've only removed myself recently from those pickup and drop-off situations because of the third party's involvement creating such a physical and legal liability for myself. So what I did to render that situation was remove myself from it.
You understand that that issue really isn't before the court today, that you filed a motion that's going to be heard by the referee, right?
Correct.
Judge, I have nothing else. Thank you.
All right. Thank you very much, Mr. Wilson. Counsel, how would you like to resolve any issues going forward? What do you want me to order today? What do you prefer, Mr. Blumberg?
Judge, we would ask the court just maintain the status quo until such time as the court's satisfied that there's no need for the current restraints and limitations. I don't think we've heard very much today that should change the court's view of what you put in place the last time we were here.
Mr. Schraub?
Thank you, Judge. I mean, from my perspective, you know, we can't just sit here and continue to maintain the status quo indefinitely. I mean, the goal here, as I understand it, is to work back towards what parenting time Mr. Wilson had with his daughter in the past prior to this incident in December of 2024. I think you've heard today that, well, first of all, let me just say that a significant period of time has gone by since that incident occurred. Mr. Wilson is in therapy. His daughter's in therapy. It sounds like from his testimony and from Ms. McMaster's testimony, the child is doing well, progressing. So at some point we need to move the ball down the field, and I think that point ought to be today. If there's issues, obviously the parties have the ability to avail themselves to the court again. But at some point we got to stop standing on the beach and get in the water. So I would ask that the court lift the restrictions that it imposed by way of the referee and its own order back in September of 2025, and instead do a every other weekend visit with Friday after school pickups and Monday morning drop-offs.
My understanding of the order prior to the referee and then my decision after the referee's objection hearing was that it went back to 2019 where Mr. Wilson had, I believe, 3 or 4 weekends and Ms. Hofstra had 1 weekend a month. Is that, am I accurate as to that pattern of parenting time?
I believe you are, and I think that's why you fashioned this last order to afford visits every 3 weekends per month.
All right. Here's what I propose, and I'm willing to listen to argument on that. I think what we should do is, I've not heard from Mr. Wallace through no fault of anybody's. I understand I didn't require that to be done, but it was nice to hear from Ms. McMasters. I'd like the therapists to talk to each other. That will require the parties to sign a release. And if the therapists agree that we can go back, we're at a spot where we can go back to the original parenting time order, which would have been the 2019 order that was before any of this happened, then I would allow that to occur. If the therapists within the next 45 days, 60 days, whatever time period we want to set, can't agree on that or don't think that it would be a good idea, then I'd like to have one side or the other set this for a full hearing with the therapist to be brought in, and I can hear from both of them with cross-examination and arguments and the whole shooting match, and make a decision at that point about what restrictions, if any, should be remain and for how long going forward. But I'd like to have the therapists talk to each other so that they are aware of what the other is doing, how the child and how the dad are making progress, and what, if any, restrictions need to be kept in place, or whether there needs to be some further counseling to address specific issues. Mr. Blumberg, your thoughts on that proposal?
I think that's a reasonable way to proceed, Judge. I think it's a good idea.
Mr. Schraub?
I'm not opposed to that. I guess the question I would have for you is if the therapists are on the same page that, you know, parenting time should be expanded in some way, shape, or form. Certain restrictions should be lifted. Certain restrictions should remain in place. How do you want us to get that in the form of an order? I mean, would you expect us just to stipulate to that, or do we need to have it reviewed by you?
If you can't stipulate to it, that would be an appropriate time to file a motion to say, here's what we think the therapists say, and let's have a full hearing on it. So my hope is that after the therapists talk to each other, that the attorneys can talk to their individual therapists as well, and say, all right, do we believe we've had an agreement? Let's put out a stipulated or a proposed stipulated order there, and let's get it signed. And if we won't sign it, that's your cue to file the motion. So that's kind of what I'm looking for at this point.
Understood.
Very good.
Who wants to prepare that order for me going forward?
Mr. Blumberg does.
I'm sorry, I took a step back. I didn't take a step forward. I think Mr. Schrock can get it done more quickly than I can.
I can do it, Judge.
We question the accuracy, but at least it can be done.
All right, thank you, Mr. Straw. So we're looking at the parties, the therapists talking together, trying to reach a resolution. The attorneys then circulating a proposed order. And if we can't get a resolution within the next 60 days, I'm going to ask that one side or the other file a motion to bring that before the court, with the parties having their therapists available for that hearing. If you could kind of summarize that for me in the order, I'd appreciate that, Mr. Straw.
Sure can. Thank you.
All right, that's all for today. Thank you all very much. Appreciate your time. Holly and Scott Togetska, file 25-20265-DM.
Good morning, Your Honor. Angel Anderson on behalf of Holly Togetsky.
I do not have Mr.
My client is not here today, Your Honor. She has a family emergency.
All right, do we have the other party present?
I have not heard from him.
Is he in pro per?
He is, Your Honor.
Ms. Anderson, how do you want to proceed today? What court orders are you asking me to enter at this point?
Your Honor, just an update. I have made a self-referral for mediation. My client and I are in talks about a spousal support motion. This case definitely warrants it. Unfortunately, due to the family emergency she's been dealing with, we haven't been able to get together on that. So I do expect we'll be filing that motion. Mediation will be reaching out to schedule. Looks like we have a pre-trial scheduled in this case in late June. So at this point, I think we just like more time so we can sort this through, go through mediation, and see what decisions we can come up with in terms of property, debt, and spousal support.
So is there a child support objection pending in front of referee legal later today or later next week?
There is, Your Honor.
All right. So is there any, looks like we did a pretrial order back in February. I set discovery at 60 days. Any further need for discovery?
No, Your Honor. Mr. Tolgeski has been compliant with all discovery requests, so we have everything we need at this stage.
All right. And then you're going to set, I think I referred community mediation after discovery, so you've already got that in process?
I do, Your Honor. It's not been scheduled yet, but they have the parties' information and know that we are going to need mediation. The timing of the spousal support motion is kind of hindering us, but again, I think we can move forward with that once my client is free and able to focus on that.
So I'm just going to indicate that community dispute resolution, I assume that's what you're going to use? for mediation?
Yeah, our local one.
All right. I said another pretrial. Let's see, you said you think there's one in June?
There is, Your Honor. It's, I believe, oh, don't quote me now. It's June 26th, I believe. It's later in June.
All right. Let's just leave that in place. I won't actually enter a further order for today's hearing because I don't think anything is necessary. You've got things in place already. If you need something, June 26th should be a appropriate date. I'm hoping that you can get into your mediation prior to that, although maybe that's pushing things a little bit. And I'll let you do your motion on spousal support. Hopefully that's something that you can talk about in mediation as well. But if necessary, we'll set any further stuff at the hearing in June. Is there anything else that we need to do today?
Not at this point, Your Honor. Thank you.
All right. Thank you for being here. I appreciate it.
Enjoy your holiday weekend, everyone.
You too.